We'll kickstart this edition with some news just coming in from the High Court in Karnataka on the Hijab Showdown. The hearing is underway right now. The High Court is asked if essential religious practices are absolute and if it can't be subjected to regulations. The petitioner referring to the triple talaq judgment. Nolan Pinto getting us the very latest as far as the court's developments. The developments within the court is concerned. Take us to the reference herein to the triple talaq judgment, Nolan, that the petitioner has made. Break this down for us.
Well, Sneha, Advocate Karnataka says if Islamic scriptures of the Holy Quran says this practice is obligatory, then courts have to permit it. In the S. Bano case, the Supreme Court held the triple talaq practice was not sanctioned by the Quran. This is what he says. Now, that is when Justice Dixit then questions, says, Mr. Kamath, whether what all stated in the Quran is essential religious practice. This is what he questioned him. Is what all stated in the Quran an essential religious practice, ERP? That is when Advocate Kamath says, I am not saying that. So we're just waiting for more updates to see what really happens over here. But Sneha, very interesting points that they have come out with. I just want our viewers to know that, because in the past 5 odd minutes, Advocate Kamath has actually brought in a lot of important issues. In fact, he refers to one particular case. This is at the Shirur Mutt. This is right there in Udupi itself. He says, and I want to quote him, a religion may not only lay down a code of ethical rules, it might prescribe rituals and observances which are regarded as integral parts of religion, since we were talking about integral part of religion or essential part of religion. And these observances might extend even to matters of food and dress. Then he also refers to, he quotes from the Ratilal Gandhi case saying, no outside authority has any right to say that these are not essential parts of religion, and it is not open to the secular authority of the state to restrict or prohibit them under guise of administering the trust estate. So these are very strong arguments that he's putting forth. However, the Karnataka High Court has actually questioned him, asking, what about Article 25, subsection 2? Kamath says that Article 25.2 has, for the state has been given the power to restrict any economic, financial, political or secular activity associated with religion. This very concept means that other core religious activities of religion can be restricted. The High Court now, this is important, questions him, says, can Article 25.1 and 25.2 be read separately? He says yes. But the Karnataka High Court says if one reads the Bijo Emmanuel case, it does not distinguish between Articles 25.1 and 25.2. And this is what the High Court says, that Articles 25.1 and 25.2 have to be read together. So these are the arguments which are actually going on as of now. Sneha.
I'm going to go to my colleague Nabila for more on what is being asked about the Holy Quran. The High Court, Nabila, essentially asking whether this really is the first source of Islamic law and whether that everything stated really in the Holy Quran should be treated as inviolable.
Right, here, Sneha, when we speak of the Holy Quran, it is almost like the word of God. There is no debate on what the Holy Quran says for a practicing Muslim. They would go by the word of the Quran, but there's a lot of talk about, I mean, apart from what the court is hearing currently, we're also looking at several scholars who've been insisting that there is no specific mention of wearing the hijab in the Quran. It speaks of dressing modestly, but nothing specifically mentioned about wearing the hijab, about wearing a burqa or a veil, etc., which is why it's going to make it slightly tough for the court now to try and break it down to see how is it so essential and whether the Quran itself mandates it. Now, there are several interpretations of the Quran too, Sneha. I must tell you, there are Sharia interpretations to the Quran and there are several Sharia interpretations to the Quran. In fact, Darul Uloom, which is one of the Islamic centers in India, the most popular, the largest one, which is in Uttar Pradesh, they have a certain rigid way of interpreting the Quran, while there are several other institutions that interpret the Quran individually. But what we see in common of all these interpretations is the hijab. that women across the globe, in fact, Muslim organizations have, or the Sharia interpretations across the globe have insisted on parda, basically the hijab, covering the hair most particularly, but no mention or nothing specific about covering the entire body or wearing the black burqa that we usually see women wearing, or the whole black veil. That's not mandated, but certainly what's common across all of the Sharia interpretations is that wearing the hijab, which means covering the hair, and wearing your arm full sleeves, like full sleeves, not showing your hand, is what should be, is how women must be dressed according to Islam. This is what, according to them, is their interpretation of being modestly dressed. But then, again, it comes down to a lot of debate whether how women would look at it as whether this is their choice or whether this is imposed on them. That's also a huge discussion there. Many countries actually impose hijab despite women not wanting to wear it. And on the contrary, we're seeing a different debate here altogether. Women wanting to wear it, but here the state government has certain discipline that needs to be that they want to ensure inside classrooms. It is a fine line which the court will be discussing and deliberating on, which is why a verdict today itself seems unlikely here, Sneha.
We'll come back to you for more. Nabila, be with us. Going back once again to Nolan. Nolan, here the petitioner arguing essentially that there are no two thoughts about it, talking about the fact that the Quran itself is talking about headscarves. So where's the question of another authority commenting on it or of passing an order? The Quran essentially is the final word when it comes to Islam.
Well, in fact, this is what Advocate Kamad says, Sneha. He says, if Islamic scriptures of the Holy Quran says this practice is obligatory, then courts have to permit it. And this is when he spoke about the triple talaq issue. That is when Justice Dikshit asked him whether everything that is stated in the Quran is ERP, essential religious practice. He says he's not saying that. That is what Advocate Kamad says. Then the High Court asks whether all Quranic injunctions are inviolable. This is a very important question. That is when Advocate Kamad says, I would not like to comment on larger issues, whether every tenet mentioned in the Holy Quran is essential religious practice. He says that for the purpose of this case, hijab is essential. He also adds that the larger question whether all Quranic injunctions are essential religious practice does not arise in this case. He says, I beseech your lordships to not get into that particular issue, but only to focus on the hijab issue as an essential religious practice, or ERP. He also refers to the quote that Islam cannot be anti-Quran in the triple talaq case. And he says, I rest my case on that, adding what is bad in the Quran cannot be good in Sharia. That this is how the Supreme Court summed it up in the triple talaq case.
Interesting argument there, Nabila, with Advocate Kamad essentially drawing this comparison, saying that because triple talaq is not an essential practice as per the Quran, it was struck down by the courts.
Right, this is what has been seen in the past too, Sneha, but then it all comes down to, again, if you're speaking of essential practice, this is a practice that's been followed for decades, Sneha. In fact, Muslim women have been wearing this for over 10,000 years. They've been following the parda system. Earlier it was a full black veil. You'd see a very common sight of people wearing burqas. Now they've come down to just covering the head as a scarf, just the hijab, which is the head scarf that covers the head. So it seems like an age-old practice that even if the court actually comes down to establishing that this may or may not be an essential practice in Islam, the fact that it has been followed as a tradition for generations to come will also have to be looked at thoroughly. This will disturb, if at all the verdict is against hijab being worn inside classrooms, it will disturb those girls certainly who have been wearing hijab since the age of 7, whether it is their choice or whether this was forced on them. The fact is that they've been wearing it for so many years, and now to take off the hijab and enter classrooms also might be a slight challenge. On the contrary, it will also establish what uniformity means in this country, how uniformity is really defined, which is why we're really closely watching this discussion here today, because this will really define a lot of blank spaces which now need to be filled, considering that there seems to be an outrage across the country where Muslim women feel like this judgment or this order that the Karnataka government has given will trickle down to their respective states, and they fear for their well-being of or their right to wear the hijab in their respective states. So it appears that all of them have come together to condemn this and ask for their right, demand for their right under the Constitution. Let's see how they're going to be interpreting the Constitution and the fundamental rights given.
So, and the kind of bearing, Nabila, this really essentially, in months and years to come is going to have on women's education from the Islamic community, because you did tell us earlier, and we've been reporting on this relentlessly, how women actually said, we do not want online education if this is the issue. We want to go back to our colleges and schools with the hijab on. How many women will be actually comfortable to take the hijab off and go back to their schools and institutes is a big question, isn't it? It's a big concern that at the end of the day, education of these women might just suffer.
Right. You know, Sneha, we're talking about different kinds of Muslim women, right? You have one sect of Muslim women who do not wear the hijab, who practice Islam, do not wear the hijab. There are other kinds of Muslim women who have not worn the hijab all through their childhood, have taken up the hijab much later on in their life when they feel a lot more conscious about their religion and they feel that they want to immerse themselves and follow what the Quran says. And that's when they take it up much later on in their life. There are women who bore it from their childhood and then take it off much later in their life, and they feel, they feel different, they don't believe in it anymore, and therefore they change their mind and they take off the hijab. So that's what we've seen as rampantly across the globe, where women, fluctuating with their choice in wearing the hijab. Some wear it because they want to wear it for a certain period of time and then they take it off. But those who are wanting to wear it, it is their personal choice as per mandated under the Constitution. Now, will that personal choice infringe upon unity or uniformity and equality inside classrooms? That's for the court to tell. But this is a personal choice, and freedom of choice, freedom of expression, again mandated in the Constitution. Will that be upheld over uniformity? That remains to be seen. But yes, there's been a constant debate about, you wore it yesterday, you're not wearing it today. You wore it today, you're not wearing it tomorrow. That kind of debate has been going on, but that's redundant. Because in Islam, according to the women, it says it gives them choice to choose and take up the hijab as and when they want to, and they shouldn't be questioned for it.
Okay, Nabila, be with us. I'll just come back to you for more on that. Going back once again to the proceedings from the Karnataka High Court, Nagarjun Dwarkanath also tracking those developments very closely. Two things that Advocate Kamath essentially has said about the role of the state. I want to put that out, Naga, and do talk to us about it. Irrespective of whether or not it is an essential practice, Advocate Kamath says the state is duty-bound to ensure freedom of conscience, and also says that letting the College Development Council essentially decide on these matters is total abdication of state responsibility.
Well, that's absolutely true, and also is arguing right now that the Constitution says Article 25 will be subject to public order. Now, who decides the public order? Is it the college committee or the state? And who is in the college committee? It's an MLA. So at the end of the day, you are essentially leaving the public order to be decided by an MLA and a college committee and not the state, is the big question that the advocate is questioning or putting in front of the bench, that Constitution only says Article 25 will be subject to public order. But who decides the public order? That's the big question. Now the government notification says that the public order will be decided by MLA, who is the chairman of the college committee, college development committee. That essentially does not fit the books, because public order is when the law and order situation arises and the state has to take into consideration, and who decides it cannot be a college committee. He also quotes, says that the Quran itself says that in respect of headscarf, that they do not need any other authority to give them permission. So if that is the case, that the Quran has mentioned itself, will they need anyone's permission to wear it? Because as soon as the Quran says it's compulsory, it automatically comes under Article 25, is what Advocate Kamath is saying. And he also says that the person who has drafted the government notification has not looked into Article 25, because without keeping Article 25 under consideration, this random notification was put into place to make sure that these such students and such one particular particular community students will not be allowed to enter with the uniform, with the headscarf alone. And that's the argument that he's making. In another 15 minutes, we'll hear it, because last Thursday too at 4:30, the Chief Justice said that it's time for the day, and we'll hear it tomorrow. If it's unlikely that we'll hear an interim order today too, in another 15 minutes, the day will be done. If the order doesn't come up in next 15 to 30 minutes, most likely the issue again will be heard tomorrow by the three-member bench.
Absolutely, but also the other set of arguments, Naga, and talk to us a little about that as well, is Advocate Kamath questioning the very basis on which this order essentially was passed, asking what is the legal basis of the MLA committee, given that it has an MLA in it, to decide what is law and order, and also to decide on fundamental freedom and what essentially, like I said, constitutes law and order, constitutes public order. What is the authority is the question the petitioners are asking.
That is true. In fact, like I said, public order is decided by the state, not the college committee. And will you leave it to an MLA alone? Mr. Kamath, who's the advocate for the petitioner, also adds that our MLA is not aware of constitutional provisions. They will do whatever they want accordingly. This is the college committee is an extra legal committee. Look at the repercussions. I understand the state doing it, but leaving it just to the committee to decide if the students can wear headscarf, and if they wear, it's going to be a reason why there's a public order in state. Who will decide? The state has to be the decision maker at the end of the day. The government should be the decision maker, but do not leave it to a college committee. Day one itself, Mr. Kamath said that why should my student, my petitioner, be at the mercy of a college committee? It's my right to freedom, my right to religion. That Quran says it's compulsory for me to wear a headscarf. Will my fundamental right be in front of or decided by the MLA of a college committee? This is not right, and this is not causing public order. Even if it causes, it is the right of the state to decide if it's public order. Please do not let the committee decide, is what the petitioner advocate is saying. The Chief Justice is also hearing still, and Mr. Kamath has also again said that whether right to religion offends the public order has to be decided by the state. The Chief Justice says the government order does not say anything about public order. The government notification only says that the uniform will be decided by the College Development Committee. We are again back to square one about talking about who decides the public order, and does the college committee know anything about Article 25? Does the government notification talk about anything about Article 25? Again, back to the basic hearing about Article 25 is going on right now.
Be with us, Naga. For our viewers today, well, the Karnataka government essentially had ordered that schools and institutes will be closed, given that there is a threat to public law and order. Today is the day when they opened up. And Mustafa, tell us a little about what was really seen on the ground when it came to women, many of them being disallowed